Hello and welcome to Thompson Coburn's webinar series. Today we're going to be spending the hour talking about dealing with financially troubled customers outside and inside of bankruptcy. My name is Brian Hockett and I'm an attorney with Thompson Coburn's Financial Restructuring Group, in which I spent about 12 years assisting creditors with their troubled customers. And I'm joined today by my colleague David Farrell.
Good day, everyone. My name's David Farrell. I'm a partner in the Bankruptcy and Restructuring Group at Thompson Coburn. I've been practicing in the bankruptcy area for 25 years and have focused my practice on representing trade creditors and representing unsecured creditors committees in Chapter 11 proceedings.
Briefly on the agenda, we are going to cover a few pre-bankruptcy tools that might want to be considered when dealing with a financially distressed customer, and then we'll talk about a few bankruptcy topics that we think are important for dealing with trade creditors, dealing with our customers. And with that, I think we will get into the substance of our presentation. David?
Thanks, Brian. Just real quickly, we thought it would be helpful to give an overview of the general bodies of law that we're going to be touching upon throughout the presentation. The first general body of law that we're going to be touching on is Article 2 of the Uniform Commercial Code, and as many of you may know, the Uniform Commercial Code is a series of commercial laws that have been adopted in all 50 states. It's state law, but they have been fairly uniformly adopted in all 50 states. Article 2 of the Uniform Commercial Code deals with the sale of goods. We're also going to be touching upon Article 9 of the Uniform Commercial Code, and that's the state law that governs the process of obtaining a consensual security interest in the assets of a borrower, in our case, a customer to whom you may be selling goods. The final general body of law that we're going to be touching upon is the United States Bankruptcy Code, which is a federal law that governs the bankruptcy of both companies and individuals. The first topic that we wanted to address was purchase money security interests, and that purchase money security interests are a mechanism through which a trade supplier can obtain a legally enforceable security interest and lien in the goods that it's supplying to a customer. And the importance of and value of obtaining a purchase money security interest, in a situation in which your customer becomes insolvent, and if your customer has already pledged all of its assets to a bank lender, the purchase money security interest may be the only mechanism through which you can realize recovery. And without a purchase money security interest, you may find yourself in the very uncomfortable position of sitting back and having to watch as the goods that you've supplied to your customer are liquidated, and the proceeds from that liquidation go to repay a secured lender. So by utilizing the purchase money security interest remedy, you can avoid that outcome. So how do we go about obtaining a purchase money security interest? First of all, we have to obtain a security agreement describing the collateral. The goods in this case would be the goods that are being supplied by the supplier to its customer. And that security agreement must be authenticated by your customer. And authenticated is just a fancy way of saying the security agreement has to be signed or acknowledged in some way, and the use of the word authenticated is intended to cover kind of the modern means through which folks can acknowledge agreements, electronic signature and that kind of thing. And a security agreement really can take any type of form. You could, for instance, include a security agreement as part of the credit application. So you could have as part of your credit application a provision under which the customer would grant, as part of that credit application, a security interest in any goods that you supply going forward. Second requirement for obtaining a purchase money security interest is it must fit within the Article 9 definition of purchase money. And if we're talking about obtaining a security interest in the goods that you're supplying to a customer, you're going to fit within that definition. Another requirement for obtaining a purchase money security interest is you have to file a UCC financing statement. That's essentially a one-page form that must be filed with either typically with the Secretary of State in the state in which your customer is incorporated or otherwise organized. Now, if the goods you are providing to your customer are goods that your customer is going to resell to third parties, then Article 9 characterizes those goods as inventory, and in order to obtain a purchase money security interest in those goods, you're going to need to file your UCC statement before those goods are received by your customer. Now, if it's another type of if your customer is not a reseller of the goods that you're supplying, let's say you're supplying equipment, and your customer is going to use that equipment in its manufacturing operations. In that case, it is not necessary to have a UCC filing in place before the goods are received, but you must file that UCC statement within 20 days of the delivery of the goods or the equipment to your customer. A final requirement for obtaining a purchase money security interest, and again, this only applies in those situations in which the goods that you're delivering are inventory in the hands of your customer. That is, your customer is going to sell those goods to third parties as a retailer or reseller of those goods. And if you fit within that category, then another requirement that you must comply with is to send notice to those folks that may have an existing inventory lien on the customer's inventory. And in order to find out who those folks are that have liens on your customer's inventory, you're going to have to do a UCC search. So, real quick question here with regard to we have a lot of clients that we recommend getting purchase money security interests, and the question always arises, well, do I have to file this UCC statement every time I supply new product to the same customer? And the answer to that is no. That a UCC financing statement is good for 5 years, so you get it on file and it's good for 5 years. You'll have to renew it after that 5-year period. And the same applies with regard to the purchase money security interest notice to other pre-existing bank lenders who may have a lien on inventory. Real quickly on some of the limitations on purchase money security interest. It is an important and very advantageous remedy, but there are some limitations. First of all, if your customer resells the goods that you have obtained a purchase money security interest in, your purchase money security interest status will not continue in the goods when they're in the hands of the third party. So then the question arises, well, what about the proceeds that my customer receives? Am I going to have any type of lien rights with regard to those proceeds? Well, if your customer sells the goods on credit to a third party, let's say on 30-day credit terms, that's going to give rise to an account receivable that's owing to your customer, and you will have lien rights on that account receivable. However, Article 9 provides that you kind of lose your purchase money priority on that receivable, and if there's an existing lender out there that has a lien on accounts receivable, then you will be your lien position will be subordinate to that accounts receivable lender. And then another limitation that comes into play, if let's say your customer sells the goods for cash, you will have a lien on those cash proceeds, if it's a cash transaction, but your purchase money status is limited to only cash proceeds that remain identifiable, and often cash proceeds get commingled with other cash sources, so it's very hard to trace through and establish a continuing priority in cash proceeds. Probably the biggest limitation that we confront in terms of having clients obtain a purchase money security interest in goods that they're selling to a customer is that often the customer's existing bank lender will have a prohibition in its loan documents that prohibit the customer from granting any type of lien to other parties. And customers are very reluctant to act in violation of those covenants because it would create a default under their bank documents and conceivably give the bank lender the ability to foreclose on all the customer's assets. So that's kind of purchase money security interest in a nutshell. Another topic that we wanted to kind of that goes hand in hand with purchase money security interest is consignments. And what a consignment is, in the traditional sense, is an arrangement in which a supplier provides goods to a retailer to sell to third parties on the supplier's behalf. And under this arrangement, the supplier typically retains title to the goods even when they're in the hands of the retailer. So if the retailer becomes insolvent, the supplier can typically recover its goods, even those that are in the possession of the retailer, because the supplier, again, is considered the owner of those goods. And kind of recognizing the advantages of that outcome or that arrangement, some suppliers started characterizing their relationship with their customers as a consignment to simply guard against the possibility that their customer might end up insolvent, in which case the supplier wanted to get back its goods. And so that gave rise to a big kind of recurring legal dispute as to whether or not a particular arrangement was a true consignment, or was it simply an arrangement that folks were characterizing as a consignment in hopes of improving their position in the event that the customer became insolvent. So the drafters of Article 9 kind of said, well, we're going to just simply avoid this whole debate about whether something's a true consignment or kind of a disguised financing, and we're going to say, regardless of whether it's true or it's disguised, you still have to comply with what are essentially the purchase money security interest rules, and that is filing a UCC before the goods are delivered to the customer so that the whole world knows that you have a unique relationship with regard to these goods, and you would also have to provide notice to any existing inventory lenders that the goods that you are supplying are being provided on a consignment type of arrangement. So with that, we'll turn to the topic of stoppage of goods. Brian?
So we were just talking about a tool that's available really for planning in the event that your customer becomes insolvent. Now we're going to turn to a topic that would need to be addressed fairly quickly after you discover that your customer has become insolvent, and that's stoppage of goods in transit. Stoppage of goods in transit is governed under Article 2 of the UCC, and essentially what it means is that if you've already put your goods on a truck to go to your customer, what can you do in the event that you suddenly discover that your customer is insolvent? Well, two things here. First, you can refuse to deliver any goods unless the customer pays in cash for such goods, and also pay for any unpaid goods that were also delivered under the same contract. But important for this topic is that you can also instruct your common carrier to stop delivery of any goods that are already in transit to the customer. And so that's true even if the title technically passes to the customer, or that it's the common carrier that's been retained by your customer. And you have to do that by providing clear instructions to the common carrier, to the trucking company, the shipping company, to stop delivery of those goods in transit. Let's look at a quick example on this. Let's suppose that the trade creditor agrees to sell 5 tons of pig iron FOB New Orleans to customer who's located in Decatur, Alabama. The supplier delivers the pig iron in New Orleans. It's loaded onto barges, and the common carrier is en route. Suddenly, the trade creditor discovers that their customer is insolvent. And so what they can do is they can provide instructions to that common carrier to stop delivery. And typically, certainly that should be communicated in every reasonable way possible. It would be best practice to communicate that in writing as well. But obviously, given the very short period of time that might be available to provide those instructions, it should be provided in every reasonable way. And the result of that is that the common carrier is obligated to stop delivering those goods. And and kind of to protect the common carrier, it's the supplier that's going to be responsible for the resulting charges or that might result from stopping the delivery or reshipping it somewhere else at the supplier's instruction, and they would also be responsible for any damages that the common carrier might otherwise incur. Now, the right to stop delivery is going to end when, obviously, the common carrier delivers the goods to the customer. It could also end, that right to stop delivery could also end if the customer has provided the common carrier with instructions that would redirect the shipment of goods. Also in situations that are fairly common where a supplier, trade creditor, is actually drop shipping the goods for their customer. In those instances, the right to stop delivery wouldn't exist anymore. Obviously, it's a very tight time frame, so this is something that has to be acted on very quickly. One additional exception I think that's important to note is that the right to stop delivery does not apply where the goods are being shipped in smaller quantities. So if you're working with a freight forwarder who may have consolidated loads for shipment, at that point, you're not going to have a right to stop delivery because obviously you can't interfere with the shipment of other parties' goods. And then we're going to move on to another topic that is also important to act on fairly quickly in the event that a customer is insolvent.
Yeah, so the next topic we're going to address is reclamation rights, and this kind of picks up where the right of stoppage of goods leaves off. So if you weren't able to get a hold of the common carrier and before the goods were delivered and their goods are now in the hands of the customer, the right of reclamation kicks in and gives the trade supplier the ability to reclaim or regain possession of the goods that it delivered to a customer who has become insolvent. Some important timing limitations on asserting this right. In order to properly exercise the right of reclamation, ordinarily you must make demand upon the customer within 10 days of the customer's receipt of the goods. So that's a fairly narrow window. Now that 10-day limitation does not apply in those situations in which the customer has made a written misrepresentation to you, the supplier, regarding its solvency within 3 months of the delivery of the goods. So if the customer has made that type of misrepresentation to you, then you're not going to be subject to that narrow 10-day period for making a reclamation demand. Although reclamation is an important remedy, there are some significant limitations on its application and applicability. One of the significant limitations is that the goods still must be in the hands of the customer and must remain identifiable at the time that the customer receives your reclamation demand. So, for instance, if the customer at the time, before it receives your reclamation demand, has already sold the goods to a third party, or let's say they've consumed the goods in their manufacturing process before your reclamation demand is received. In those circumstances, your reclamation demand will not be valid. Another huge limitation is if your customer has a pre-existing inventory lender, that is a bank lender that has a perfected security interest in your customer's inventory, that lien will prime your reclamation rights. And so that's a very important limitation that often comes into play in the real world. Another limitation is, as a technical matter, if a trade supplier is aware of a customer's insolvency before it ships out goods, then the right of reclamation as a technical matter does not apply. It only applies in those situations in which the trade supplier becomes aware of the customer's insolvency after the goods have been shipped. Another important consideration is that let's assume that you do have a valid reclamation demand, that none of the problems that we've just covered apply. Even if you have a valid reclamation right and you've properly asserted it and made a timely demand, unless the customer is willing to comply in voluntarily returning those goods, in order to enforce your reclamation right, you're going to have to bring a formal lawsuit to recover those goods. And that, in most jurisdictions, that action is going to be called a replevin action. But that obviously involves the incurrence of legal fees and the time and expense of pursuing litigation.
Okay, the next topic we're going to talk about is what happens when your customer files for bankruptcy. And last year we presented another CLE program on Bankruptcy 101, Bankruptcy Basics, in which we covered a lot of the basic topics around a bankruptcy filing. So we're not going to cover a lot of those issues today, but we are going to delve more deeply into the topics that are relevant to trade creditors and those trade creditor-specific issues. If you are interested in additional background information on bankruptcies and bankruptcy filings, this CLE presentation on Bankruptcy 101 is available on the hyperlink that's on this slide. The first topic we're going to cover here is going to be claims in bankruptcy, and I'm going to cover this fairly quickly. I mean, a claim in bankruptcy is if you are entitled to recover money from the debtor, you are entitled to file a proof of claim, and a proof of claim is a fairly simple form. I think the most important thing for trade creditors to know is that there is going to be a claims bar date that's set. It's pretty clear on the notice of bankruptcy filing when the claims bar date is set, or the debtor or the estate is required to send out a notice that will provide a creditor with notice of when a claim must be filed. I think that deadline is very important, and in order to participate in any distribution from the bankruptcy estate, whatever that's going to be, even as a general unsecured creditor, you will need to file a proof of claim form. I'm going to talk a little later, so probably the next slide, about 503B9 claims, and those are actually done not on a proof of claim form, but usually they require the filing of a formal motion or application with the bankruptcy court so that that claim can be allowed. Generally, claims are going to be considered valid unless they're objected to in writing by the debtor or some other estate representative. And if a claim objection happens, then you have to obviously prove up your claim at that point. On 503B9 priority claims, this was added to the Bankruptcy Code in 2005 when Congress made several amendments to the Bankruptcy Code. And what a 503B9 claim is, it's referring kind of shorthand for an administrative priority claim. And this is for unpaid suppliers to the extent that they have claims that are for goods that were received by the debtor in the ordinary course of business within 20 days before the debtor commenced their bankruptcy case. So administrative priority is good. They get paid first. So this is very advantageous to suppliers of goods. They are going to be entitled to an administrative priority claim, which is paid before most other claims in the case. Obviously, there's going to be secured creditors that are out there, but in a business case, the administrative priority claims are going to be a top level claim, and they certainly get paid before general and secured claims. So obviously, the most important the limitations here are that it has to be a supply of goods. So it does not apply for, say, services. It's not going to apply to finance charges, taxes, freight charges, things like that. It's going to be the value of the goods that were received by the debtor. And the goods have to be sold to the debtor in the ordinary course of business. This was in order to avoid the debtor doing some pre-bankruptcy planning in concert with a trade creditor. I mean, they can't say, hey, I'm going to file for bankruptcy. Can you deliver me, 20 times my normal order within the 20 days before bankruptcy? You're going to get an admin claim for it. That's not going to work, and would obviously not be advisable to try that. Let's just advance more unsecured credit to a debtor, but right before they file for bankruptcy. It doesn't sound like a good idea anyway, and 503b9 is not going to provide any protection. The goods have to actually be received by the debtor within 20 days before, so it's not just what your invoice date is. You're going to need to look at when the delivery actually occurred, and so that's been litigated in several cases when a debtor actually receives those goods, and that's an important caveat to this protection. It has to be delivered, put into their possession within 20 days before the commencement of bankruptcy. And so what this means is the trade supplier is going to actually get an admin priority claim for the value of the goods. And so what you're looking at here is, again, your goods that you're getting a priority claim for. And in a Chapter 11 case, admin claims have to be paid upon the effective date of a plan, so you're going to get paid first, and it's very advantageous, and so it's an excellent tool that was added in 2005.
Okay, we're going to talk about reclamation rights in bankruptcy. We spoke earlier about reclamation rights outside of bankruptcy. Now we're going to address the same topic in the context of a bankruptcy proceeding. And since its enactment in 1978, the Bankruptcy Code has recognized, subject to certain additional qualifications and requirements, state law rights of reclamation. And courts have uniformly held that the Bankruptcy Code's automatic stay provisions, which generally prohibit creditors from undertaking any actions to collect their pre-bankruptcy claims once a bankruptcy has occurred, that provision has been uniformly recognized as not preventing a trade supplier from making a reclamation demand after bankruptcy is commenced. And similarly, I'll just mention as an aside that the courts have also uniformly held that the automatic stay doesn't prevent suppliers from stopping goods that may be in transit at the time a bankruptcy is commenced. So in 2005, there was some significant changes to the reclamation provisions in the Bankruptcy Code. On the one hand, those changes expanded the potential scope of reclamation rights in bankruptcy, but on the other hand, there was some provisions that significantly limited and restricted the right of reclamation in bankruptcy. So let's focus first on how reclamation rights were expanded under the 2005 amendments. What the 2005 amendments did is, we talked earlier about reclamation rights essentially covering goods that have been delivered within 10 days of the reclamation demand. That's the general rule outside of bankruptcy. But in bankruptcy, the Bankruptcy Code contemplates a reclamation right existing with respect to any goods delivered within 45 days before the bankruptcy. So any goods that you've supplied to the debtor entity within that 45-day window are potentially subject to reclamation, to a reclamation demand. And the other provision that the 2005 amendments incorporated was that the reclamation demand does not have to be made or can be made at any time within 20 days of the bankruptcy filing. So you've got 20 days from the bankruptcy filing to make a reclamation demand, and that reclamation demand can apply to any goods delivered within 45 days before the bankruptcy. So that was kind of an expansion of the reclamation rights, but some important limitations that came about as a result of the 2005 amendments. One, the amendments clarified that the rights of a reclamation claimant are subordinate to the rights of an existing inventory lender, and that was something that the courts had kind of recognized already, but the 2005 amendments reinforced that point. The other important change that the 2005 amendments brought about was that the bankruptcy code previously had provided that in lieu of actually providing for the return of goods to the reclaiming seller, the bankruptcy court could award an administrative priority claim to a valid reclamation claimant, and that was typically how most valid reclamation claims were handled in bankruptcy. And I think that was kind of a good result certainly from the creditor community. But that ability to award the alternative remedy of an administrative priority claim was removed pursuant to the 2005 amendment. So it puts the position of reclaiming sellers, puts them in the position that they now, if they want to enforce their reclamation rights, if they do in fact have a valid reclamation right, they're going to have to commence a formal lawsuit in the bankruptcy proceeding to regain physical possession of their goods. And the courts take a very strict view on that and take the position that, you know, if you wait around too long to commence that lawsuit, you're going to be deemed to have waived your reclamation rights. If it's, you know, beyond a time frame where you can realistically expect the debtor to still have possession of those goods, then the court may determine that you've waived your reclamation rights. So that limitation, coupled with the state law limitations that we covered earlier, in my opinion, make reclamation rights really a very limited and, in many cases, a very weak remedy for trade creditors. And I think Congress was comfortable with that fact because they now look to Bankruptcy Code Section 503B9 as being the primary source of protection for trade creditors in a bankruptcy situation.
The next topic we're going to talk about is preferences under the Bankruptcy Code, which I know is a topic that's very important for trade creditors, and I think probably is a dreaded word for many trade creditors. What a preference refers to is generally the provisions in the Bankruptcy Code that permit a bankruptcy estate representative to avoid and recover certain payments or transfers that were made to a creditor prior to the debtor's bankruptcy filing. Probably the most common, refrain that I get from trade creditors when they get either a preference demand or a preference lawsuit filed against them and they haven't had experience with preferences before, it's confusing because you mean I got paid on something that I was owed and now I have to actually give the money back to the bankruptcy estate? It doesn't make sense to them. And I think primarily the basis for preference law is the equality of distribution that Bankruptcy Code is supposed to provide. It's supposed to help a bankruptcy estate recover money back so that to make sure that if somebody was preferred by a debtor, that they get treated the same as all the other creditors. And I think a lot of people get caught up in the fact that it seems unfair, but in the bigger scheme of things, the point is to have an equal distribution across all creditors. I'm not saying that makes it any more fair or not, but that's kind of the reasoning behind it. Quickly to go through the elements of a preference, and I say quickly, I may take a little time to get through these. The elements of a preference that the bankruptcy estate representative would have to prove in order to avoid a preference, which is a phrase used to mean that it's recoverable, and then it allows them to recover it, is that there has to be a transfer, that is the movement of money or property of the debtor. So it's a transfer of property of the debtor. This would usually mean, in most cases, it's going to be a payment. They've sent a check to pay an invoice. And it's a payment or transfer of property of the debtor to or for the benefit of a creditor. So the recipient of the payment has to be a creditor. In most instances, the trade creditor is going to be a creditor at the time they get a check, but that would, basically eliminate situations in which you might be on a COD type of arrangement. Well, that's not exactly true. You could still be a creditor and still be getting COD, but the next element addresses the COD issue, and the transfer has to be for or on account of an antecedent or pre-existing debt that's owed by the debtor before the transfer is made. So in this instance, if you are delivering on COD, even if you're a creditor and you're delivering on COD, that wouldn't be a transfer for an antecedent debt. The transfer has to be made while the debtor is insolvent, and insolvent in this situation means that the liabilities of the debtor exceeds the debtor's assets. That just means they're balance sheet insolvent. And insolvency is actually presumed for a debtor within the 90 days before the bankruptcy filing, and this is a rebuttable presumption. It's so, one could prove, that they were not insolvent at the time that they made the transfer, but there is a presumption there that in fact the debtor was insolvent, and the transfer has to be made within 90 days prior to the commencement of the case. So that's really what you're talking about when you're talking about a preference period. The preference period is 90 days before the commencement of a bankruptcy case, unless you're talking about a situation in which the recipient of the transfer is an insider of the debtor. At that point, then the look-back period is actually 1 year. The last element is that the transfer has to enable the creditor to receive more than it would have otherwise in a liquidation proceeding, and the transfer had not been made. That is, the creditor didn't receive the transfer and there's a liquidation. In pretty much all circumstances, this means that if it's not a 100% case, meaning the creditors aren't getting paid 100 cents on the dollar, then this element's going to be met. By and large, if you're a trade creditor who's getting payment within the 90 days of debtor filing for bankruptcy, and you're getting paid on account of your existing invoices, meeting the prima facie elements, that's the case that the bankruptcy estate has to prove a preference, it's going to be fairly easy to make. That doesn't mean that when we're defending a preference that we don't scrutinize each one of these elements, and I think it's important to start with the elements, make sure they have established those elements before you turn to the defenses even. And David's going to talk a little bit about the more common defenses that we deal with, and I think it'll be helpful. David?
Thanks, Brian. So the elements of a preference apply kind of mechanically, but fortunately the Congress did set forth some statutory defenses. So these are defenses that can be invoked even when all the elements of a preference that Brian just reviewed are applicable. You can invoke these defenses and essentially say, well, notwithstanding the fact that all these elements are met, we're unable to invoke one of these defenses, and therefore the trustee cannot recover the alleged preferential transfer or payment. The first statutory defense that I'd like to address is the contemporary exchange of new value. And this is a fairly narrow defense. It essentially applies in situations in which the parties intended something to be a cash type of transaction, and for whatever reason it does end up spilling over into a credit type of situation, but the intent was for it to be a cash transaction. Probably the easiest example is, let's say you've got a customer that you've switched over to COD credit terms, and generally they're paying you at the time that you deliver goods to them. But let's say in one particular instance, payment wasn't received exactly when the goods were delivered, but got delayed by a couple of days. Well, that might be a perfect situation in which well, let me back up. You're in that situation in which you are receiving payment after the goods have been received. You will meet the prima facie elements of a preference, because you'll have a payment being received for what at that point is an antecedent debt. But nonetheless, you may be able to defend that payment from avoidance by invoking this defense and essentially demonstrating that the clear intent of the parties was for there to be a contemporaneous payment as the goods were received, and the other requirement is that you show that the exchange was substantially contemporaneous. It wasn't exactly contemporaneous, but it was substantially contemporaneous. So again, that's a fairly narrow defense. A much broader and more commonly invoked defense by trade creditors is the ordinary course of business defense. And this is a defense which requires the showing of two elements in order to qualify. The first element is that you must demonstrate that the transfer or payment that you received was in payment of a debt that was incurred in the ordinary course of business of both your business and your customer's business. And in an ordinary trade creditor situation, that's going to be a very easy element to satisfy, because it's just you're supplying trade credit to a customer, and the customer is accepting goods in order to carry on its business in accordance with the ordinary course. So that element's typically very easy to satisfy. Now, the second element contains two prongs, either of which needs to be satisfied. So if you satisfy either prong, you will satisfy this element. And the first prong is that you have to demonstrate that the transfer that is being challenged was made in the ordinary course of business or financial affairs of both you and your customer. So what is involved there is a comparison of the payment relationship that you maintain with this particular customer, before the preference period as compared with during the preference period. And if you're able to demonstrate consistency between those two periods in terms of the material aspects of your payment relationship with the customer, and you're also able to demonstrate that there weren't any kind of unusual payment practices or collection efforts undertaken during the preference period, you will be typically will be able to satisfy that element. But it's a focus on your relationship with that particular customer that is now in bankruptcy. And again, it's a comparison of what was the relationship before the 90-day preference period and what was the relationship during the preference period. Now, obviously, if there was unusual collection activities that took place during the 90-day preference period, for instance, if you were threatening to sue your customer during the 90-day preference period and there's no history of that, or if you changed the payment credit terms during the 90-day preference period, those may be disqualifying events. But absent that, and as long as you're able to demonstrate consistency between the material aspects of your relationship during those two sets of periods, you should be able to qualify. Now, typically, if there is an absence of any unusual collection activities or payment practices, a lot of the focus on this particular prong is on timing of the payments. Was the timing of the payments during the preference period consistent with the timing of payments made before the preference period? So a lot of the case law in this area is focusing on that particular analysis regarding the timing before the preference period and during the preference period. Now, let's say you're not able to demonstrate the type of consistency with regard to this particular customer that's now in bankruptcy. And that could be for many reasons. Let's say you don't really have a long payment history with this particular customer. Say you've only been doing business with them for the last, 90 or 100 days before they filed for bankruptcy. In that case, you can rely on the second prong of this element. And under the second prong, what you need to demonstrate is that the payments that you receive during the preference period are consistent with the payment practices in the industry, both your industry and conceivably the industry of the debtor. So you'd have to bring in evidence to demonstrate, that the manner of the payment, the timing of the payment, the mode of the payment, were all kind of consistent with how the general practice is in the respective industries of the parties. And if you can make that showing, that's kind of an alternative way of satisfying that element. And so if you establish that a payment's in the ordinary course, it will be fully protected from avoidance as a preference. Another important defense for trade creditors is the subsequent new value defense. And what this defense enables a trade creditor to do that has received a payment that meets the elements of a preference is to reduce its potential preference exposure dollar for dollar by any what is referred to as new value that is subsequently supplied to that customer after you've received this payment that is being challenged as a preference. And by new value, in a trade creditor relationship, we're usually talking about supplying additional goods to that customer. So one important concept on the subsequent new value defense is that the subsequent new value, the new goods, the additional goods that you supply to your customer, you can carry that back to reduce your preference exposure, but you can't carry it forward. And I'll give an illustration as to clarify that point. So we put together a little hypothetical, and essentially under this hypothetical, we've assumed that the trade supplier has, during the 90-day preference period, has received $105,000 in payments, in a series of payments that total $105,000. And then during that same time period, we're assuming that the trade supplier has supplied an additional $58,500 worth of product to the customer that it subsequently files bankruptcy. So I think the first reaction of most clients is, well, can I just simply subtract the $58,500 of new goods that I supplied against the $105,000 in preferential payments that I received and come out with a net preference exposure of, I think if you do the math, it would be $46,500. And unfortunately, because of the requirement that the new value be provided subsequent to your receipt of a preferential payment, you can't simply just net out the aggregate amount of preference payments against the aggregate amount of new value that's been provided. And instead, you have to go through kind of a chronological calculation. And what we typically do is we put together kind of a rolling chart that starts off with a beginning preference balance. You'll see that in the left-hand column. We'll start off with a zero preference balance, and we'll start with the first payment made during the preference period. And in this case, it's an $11,000 payment that was made under our hypothetical on August 8th. And so that $11,000 preference payment brings the net preference balance to $11,000, and that's reflected in the far right-hand column as our ending preference balance. And then we move on to the next event, and in our hypothetical, the next event is that the trade creditor is supplying providing $15,000 worth of additional product to the customer. And so that $15,000 of additional product, new value, can be used to reduce the preference balance, the net preference balance or net preference exposure. So you see the $11,000 balance preference balance in the left-hand side on the second row, being reduced down to zero in the far right column on the second row. And you know, obviously, we actually have $4,000 of additional new value. We only really needed $11,000 worth of new value to reduce that preference balance down to zero. But so we move on to the next event, and that is on August 29th, and we have an additional supply of $12,000 worth of product to the customer. So the question becomes, and this kind of illustrates the point I'm trying to make, is, well, can we carry that $12,000 and the $4,000 that we had left over from the $15,000 supply of new value and apply it toward against the payment that we receive on in this case, August 30th of $27,000. And unfortunately, again, because of the requirement that the new value be provided subsequent to the payment, we cannot apply that new value going forward, only backwards. So if you kind of run through all the various numbers that we provided in the hypothetical, you end up with a net preference exposure here of $62,500. And that compares to, again, the number, if you just simply netted the aggregate figures, would have been $47,500. So we thought it would be helpful to just walk through that example. Now, another important point is that you can combine the various statutory defenses that Congress has provided under the Bankruptcy Code. So you can use both the ordinary course and the subsequent new value in combination to minimize to the furthest extent your potential preference liability. The calculation of when you combine those two concepts can get very complicated, but I think the important takeaway here is that you can use both of those defenses in combination.
There's a few additional defenses that we wanted to cover today. Those are the typical defenses, but some of these other defenses are defenses that can help clients a lot, significantly in some cases. And the first two I want to cover are actually the first and third bullet points, which basically provide kind of a floor on what a bankruptcy estate is likely to pursue in aggregate preference amount. So if the aggregate value of all the property transferred, that is, the aggregate amount of the, payments, checks, that were made during the preference period to a particular trade creditor is less than $6,225, there's not going to be any preference liability, and that's called the de minimis exception. And the third bullet point is really a venue challenge, and truly an estate representative should not bring an avoidance action in the district in which the debtor has filed for bankruptcy for less than $12,475. They're supposed to bring that in the district where the trade creditor is present, and that by and large would be a bar for most estates from bringing those claims that are that less. That doesn't mean you won't necessarily get a suit for that or a demand for amount that's less than that, but that there is a venue provision that should direct a preference plaintiff that they're not supposed to file in the venue where the bankruptcy is pending, but rather in the venue of the creditor. Going to the second bullet point is the earmarking defense. An earmarking defense means that the debtor has another creditor. So we're not talking about the trade creditor that's receiving a preference, but actually there's another creditor out there that's advancing money to the debtor for the purpose of paying that trade creditor. So they may have some specific financing source out there that's advancing money for the purpose of acquiring inventory or goods or services in this instance, and that the debtor actually takes the money and then pays the trade creditor. The theory behind an earmarking defense is really they're just trading one creditor for another. The trade creditor might have gotten paid, but then there's another creditor out there that advanced the money, and now they're owed money. Really, it's kind of a net zero effect for the bankruptcy estate and for all the other creditors that might have claims against the bankruptcy estate. and that's called the earmarking defense. And then the last defense that I wanted to mention is an exemption for what's called settlement payments that are made to or by a forward contract merchant in the connection with a forward contract. And what this is a forward contract in this context is a contract for the delivery of goods in the future. And a settlement payment on one of those contracts may actually be and may actually provide a very good defense. And this is very helpful for a lot of this can be helpful for a lot of trade creditors in defending against preference liability. And I think largely you'll find that this defense will be more easy to argue and be accepted in the context where you're dealing with, more specifically commoditized type of goods. So when you're dealing with, a commodity and you have agreed to deliver that at some point in the future, and then you in fact deliver it in the future, and then you get paid for that, that transfer from the debtor would be a settlement payment, and there's actually an exemption in the bankruptcy code for those transfers from the preference liability, and that's one we've certainly had some luck with arguing as well. And that kind of covers the preference defenses. David, did you have anything else you wanted to add on any of those?
No, on the forward contract exemption, I guess I would just add that that's kind of a cutting edge, very controversial and kind of unsettled area of the law as to how broad the scope of that exemption is. The forward contract is simply defined as a contract which contemplates delivery of goods more than 2 days after the contract is entered into. So that's not much of a limitation. And so there's concern among the courts, I think, that this particular exemption could kind of swallow up the rule if applied too broadly. And I generally, there's a general thought that it's really just limited to the supply of products that fit within the traditional kind of commodities that are traded on commodity exchanges and futures exchanges. So we're talking about kind of raw materials that you see traded on futures exchanges, be it gas, coal, those types of products that are kind of raw materials that are traded on those exchanges. So, but if you fit within that category, this can be a huge benefit because it's an absolute exemption.
The question that we have is whether a cash in advance payment, and this is in the context of preferences, is a cash in advance payment treated the same as a COD for preference review? And it's not the same as a COD, but I think by and large you would look at the prima facie case that we discussed earlier. And in the prima facie case, it requires that the payment be for on account of an antecedent debt or a debt that exists prior to the payment. That is, the debtor has to be giving you a check for a debt that's already owed. In a cash advance situation, I think that the debtor would probably have a challenge in actually proving their prima facie case because this is a payment for goods that have not been shipped yet. So if you're conditioning, say shipment or delivery on cash in advance, I think that could be a valid defense to a preference. David, any other thoughts on that?
No, I would concur completely with that. If you're doing business with a customer on a cash in advance basis, you should not be facing any preference exposure.
And one of the questions was whether, in the ordinary course of business defense, if the customer is paying according to their invoice terms, say the terms of 30 days, and they're getting paid within those terms during the preference period, wouldn't a payment according to the invoice terms be ordinary course of business?
And to answer that question, the answer, unfortunately, is that that's not necessarily going to be a situation that would qualify for the ordinary course of business because again, the critical analysis under the ordinary course of business, particularly if you're relying on the prong that focuses on your relationship with the bankrupt customer, it's going to involve a comparison of what your relationship was before the preference period as compared to what was the relationship during the preference period. And if the history of the relationship before the preference period is that the customer was primarily paying you past due, maybe 20 days past due, and then you move into the preference period and all of a sudden the customer's paying you right on the due date, that for most courts is going to suggest that there's been a change in the relationship as we get closer to the bankruptcy, and the court's going to consider that a disqualifying fact in terms of your ability to invoke the ordinary course defense. So it's kind of a counterintuitive answer, but that's where the courts are.
Mm-hmm. Okay, we do have another question, and the question is, this is in the context of a PMSI, a purchase money security interest, and the question was, how do you deal with a customer that says their lender won't allow you they won't allow them to grant you a PMSI? And I think the short answer to that question is that a customer may not feel comfortable approaching their lender about that, but the counter to that is that really the lender isn't actually getting a security interest in those new goods because they're not actually advancing money for those goods. So a purchase money security interest creditor is the one who's advancing the credit for you to acquire those goods, not your lender. A bank lender should be comfortable that a purchase money security interest creditor is only getting a security interest really to the extent that they are providing new credit to the bank's customer. David, any other thoughts on that?
I would agree that academically that's the correct answer. I mean, I think my experience is it just comes down to leverage. I mean, if the customer needs your stuff strongly enough, and the bank lender should appreciate that fact. And if you have the ability to say, look, I'm not going to sell you goods unless I'm able to do it on a purchase money security interest, and the lender starts saying, hey, well, I guess my borrower really needs this stuff, then they may agree to allow you to do purchase money. But it all generally, in my experience, boils down to leverage. How important are you to your customer's business? And if you're important enough, usually you can get the lender to cooperate. And sometimes you may want to approach the lender directly about doing some kind of subordination agreement, which is kind of an alternative way of achieving a purchase money kind of status, but gives the parties an opportunity to address how that relationship will play out in more detail. So a bank might be comfortable with a subordination agreement as opposed to just simply consenting to a purchase money security interest arrangement. This question deals with an issue that's increased, that I've been encountering in increasing frequency. Let's say
explain the question. Yeah. Okay.
A customer pays with a credit card. Mm-hmm. They owe you some outstanding receivables, and they pay you with a credit card rather than remitting payment directly to you. And so I guess the question is, are you going to face preference exposure in that case, in that circumstance?
The short answer to that question, at least from what case law I've read, is yes. You can get preference exposure for that. That is considered a transfer of an interest of the debtor in property, and that earmarking defense that I discussed, I've looked at it in the context of the earmarking defense, which would be an advance for purposes of paying a creditor. It also doesn't provide any protection. If you've seen other case law on that, David, I would be interested in learning it, as I'm sure the people online would. So I am interested in that topic.
Your experience is similar to mine. There are a few cases out there that I've seen that have gone the other way, but I think that there are a growing number of courts that have treated these credit card payments as fitting within the preference provisions and have allowed bankruptcy estate representatives to come after trade suppliers that have been paid by credit card. I don't agree with the analysis. I think they kind of do a tortured reading of the preference provisions to target those payments, but that's kind of where the cases are. I think you got the majority of cases that are out there, and it is kind of a cutting edge issue, but there are a significant number of cases out there that have imposed preference liability even in the payment by credit card context.
Okay, and with that, we will end the program. Our contact information is up there on the last slide, and we are interested in hearing from any of you. And in that same vein, please do complete the survey on how we did, and also include any suggestions for any topics that you might also like to hear, within the creditors' rights area, or if you want one of the topics, we kind of moved through some very quickly today. So if you're interested in hearing more on those topics, let us know, and we'll try to work up a program on that more specific topic. Thanks for attending, and have a good afternoon. Thanks.
Thanks for the great questions.